Good evening to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for today's session. On behalf of the organizing committee, I extend a warm welcome to our esteemed dignitary, Dr. Shreya Shrivastava ma'am, and to all the participants in this 2 weeks National Capacity Building Program on Family Laws, Court Practice Procedure and Drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. It is my privilege to introduce our esteemed dignitary, Dr. Shreya Srivastava ma'am. Ma'am is currently serving as an assistant professor of law at the Institute of Law, Nirma University. Ma'am's academic and research interests span across critical areas such as family laws related to the prevention of sexual harassment of women at the workplace and corporate insolvency. Ma'am has contributed extensively to these domains through her scholarly publications and blogs, writing on the topics such as cohabitation contracts, children's rights within the family, women's alimony rights, and joint property regimes in marriage. Notably, Ma'am has also advocated for the need for gender neutral laws to address sexual harassment in workplace, particularly within the Indian context. At her institute, Ma'am plays a key role as the faculty coordinator of the Women Development Cell, where she leads initiatives on the legal awareness and conducts training programs on the prevention of sexual harassment laws. Beyond the academic setting, MAM has actively collaborated with various NGOs, including Women's Manifesto, the Working Group for Women and Land Ownership, and Bharat Vikas Parishad, to deliver sensitization and awareness sessions on women's rights. We are deeply honored to have you with us today, ma'am. Over to you, ma'am.
Thank you so much, Avneet. I hope I'm clearly audible to everybody. Thank you so much, Kalpesh sir, and Sambhav Partners, Pro Bono India, and Dr. Madhuri Parekh, who's Dean and Director, Institute of Law, Nirma University, through who all of who you gave me the opportunity to speak today. The topic that I have been given for today's session is overview of marriage, divorce, and maintenance laws in Parsi, Sikh, and Christian laws. So before I start, I would like to share my presentation, and I'll continue from there. I hope the presentation is visible on the entire screen.
Yes, ma'am.
Thank you. So I'll quickly start off directly jumping into the topic. Not much is, at least in our law schools, not a lot of times are we discussing the Christian law, the Parsi law, or the marriage regulation and registration law for the Sikhs in the country. But we do have separate religious laws for all these groups. And I'll talk just a little bit about the process of solemnization of marriage under each of these laws and what are the provisions, the grounds for divorce, followed by the maintenance proceedings under each of these laws. Now, sorry, if we talk about the Christian personal law, the solemnization of the marriage is done under the Christian Marriage Act. Now, this is a very interesting law because it has two statutes governing marriage. One of the statutes governs marriage, and the other governs divorce, restitution of conjugal rights, or divorce by mutual consent, which falls within the ambit of the Divorce Act 1890. So, for marriage, the applicable law is the Indian Christian Marriage Act 1872. And we see that the marriage solemnization can be done by persons who have been identified under this law. These persons are either the minister of religion, the marriage registrar, or any other person who has been given authority for the same. Now, these are different persons because each of them is associated and gets power to solemnize the marriage from a different source. For example, the minister of religion will be somebody who has been recognized by the church to be able to solemnize the marriage. So, on the other hand, a marriage registrar is somebody who has been given power by the state government to solemnize that marriage. However, it is to be noted that this person has to be the marriage registrar, has to be from the Christian faith. And then we have any other person who has been given authority for the same. Again, this is for those cases where civil persons who may or may not have religious knowledge and training, they have been given the power to solemnize the marriage as per the applicable rules created by the respective state governments. And however, the process of solemnization of marriage is the same in all of these. That is, a notice of the intended marriage has to be given, after which there will be a breathing period of 1 month or so, where the person, either the minister or the marriage registrar who have received this notice, they will have to put up this information on a conspicuous place, so that if there are any objections to the intended union, they can be put forth. Now we have to remember that objections to a marriage, be it under this law or any law, should only be accepted on very limited grounds which are provided for under the law itself. These could be grounds of monogamy, that is, whether the marriage is a bigamous marriage or not, or the ground of underage marriage, or the ground of prohibited degree of marriage. Now, once the period of 1 month is over, then again the parties have to come back to the registrar or the minister of religion, and the religious solemnization of the marriage takes place. This religious solemnization will be recorded in a register which is maintained by these authorities. And this register serves as a manner of registration of marriages, which is something that is that courts and even the parliament has focused on, as it should be made compulsory for the advantages that it has. Now, moving on from solemnization of marriage to separation. That law with respect to the Christians is codified under the Divorce Act. Now, the Divorce Act, the specific provision is Section 10, which is the fault based grounds of divorce. Now, the act was passed way back when India was a colony of the British. Then this act was, and after independence, there were reports that came about regarding the necessity to bring about changes in the law, because these provisions, as they stood back then before the amendment was made, these provisions were quite archaic, they were gender discriminatory, and they focused on the continuation of marriage as an institution. Whereas compared with the law in the UK, there, by the time we brought about amendments, significant changes had already been brought about in the law in UK. So, as a result of that, even presently, the provisions carry some of the older processes, which, however, have been changed after the passing of the Family Courts Act. And this is what I would like to highlight in our discussion, besides also, of course, focusing on the grounds of divorce. So, the major amendment in the Divorce Act happened in the year 2001. And what we see is that in order for a petition to be presented, the law says that it has to be presented in the district court. But from practice, from judgments, it has been made clear that the petition will have to be filed in the family court. And the family court has complete jurisdiction over the matters. Now, again, this law is gender neutral. The right to present the petition of divorce has been given to both the husband and the wife. And besides the fault grounds that are recognized under Section 10, additional fault grounds have also been given for the benefit of the wife. And though this law was passed in the year 1869, we have made changes, and we have also introduced the provision for divorce by mutual consent, which is a positive step. It shows that we are gradually giving parties more freedom to manage their own relationships and to avoid the long drawn and very vitriolic litigations that happen because of contested divorces. Now, these grounds for divorce are quite similar to the ones that we have under the Hindu Marriage Act or the Special Marriage Act. For instance, adultery or conversion from the Christian faith to another faith, which by itself becomes a ground of divorce. Then, if the person is, that is the defendant, is of incurably of unsound mind for a period of not less than 2 years immediately preceding the presentation of this petition for divorce, if the person, the defendant, has been suffering from venereal disease for a period which is not less than 2 years immediately preceding the petition, if the person has not been heard of for 7 years, if the marriage has not been willfully consummated, or if the defendant has failed to comply with the decree of restitution of conjugal rights, which was passed 2 years before the filing of this particular petition of divorce, or if the defendant has deserted the petitioner for at least 2 years immediately preceding the petition, and cruelty. So, in substance, many of these provisions are similar to what we find under the Hindu Marriage Act or the Special Marriage Act, only that some years that have been mentioned here could be different from the other laws. Now, as I was saying, the additional grounds of divorce that have been given for the wife is that if the husband has been guilty of rape, sodomy, or bestiality from the beginning of the marriage. Now, the law also speaks about divorce by mutual consent. And this is where we have to focus on and see that, there is a difference in the way the law has been framed under this particular, the provision has been framed under this particular law as compared to its framing under the HMA or the SMA. Now, here the law says that the couple, for this, in order to get a divorce according to this provision, the couple has to be living apart for a period of at least 2 years or more. Now, if you can recall, under HMA and SMA, this period is only 1 year. And then the rest of the grounds are the same. That is, in these 2 years or more, the couple has not been able to live together. The couple has mutually agreed that the marriage should be dissolved. And as happens, there are two motions which are filed in the case of divorce by mutual consent. The first motion, where the parties tell the court that they want the divorce by mutual consent, after which a cooling off period is given, which is usually of 6 to 18 months. And then the second motion, where the parties together again have to appear before the court and reiterate their decision that they want a divorce by mutual consent, after which the court will pass the relevant decree. Now, this cooling off period, just as it is under the HMA after the judgment of the Supreme Court, the cooling off period here also is directory and it is not mandatory. However, what we need to remember is that this period of living apart for 2 years, at least 2 years, this is discriminatory compared to the other laws, that is HMA and SMA. And a writ has already been filed before the Supreme Court challenging this provision of 2 years. However, the writ has not been disposed of yet, it is still pending. And at the same point of time, no amendment has been introduced by the Parliament also in this particular law. So the hope is and that the necessary change is made and it is aligned with the other laws. Now, we also have in this law the bars to matrimonial remedy, which will prevent either party from seeking divorce. What the court has to be satisfied with is that in any of the grounds that were earlier discussed under Section 10, there is no collusion to those grounds between the petitioner and the respondent, or the petitioner is not an accessory to those grounds, or else the petitioner has, if it is the ground of adultery, the petitioner has not condoned the adultery. And the the court can deny the decree of dissolution if the petitioner is if the court is satisfied that the petitioner has been guilty of the of adultery. So this has been made very clear in the statute, and this is according to the matrimonial jurisprudence, that the party which is seeking divorce must come to the court with clean hands, must not collude or must not condone the faults that have been committed in the marriage by the other party. Now, this portion is very interesting. It talks about a decree nisi, and it says that the decree of divorce, which is initially passed, is a decree nisi, which is section 16 of the Divorce Act. Now, we would know that a decree nisi is a temporary decree, and it has to be made final by passing of a subsequent decree. And the law says that the minimum time frame after which this decree is made absolute is 6 months. This provision continues to be there in the statute, that of the decree of dissolution being a decree nisi, and the time period being 6 months for its absolution. However, after the passing of the Family Courts Act, this provision has been overridden. So now the Family Courts Act has the family courts have the jurisdiction to address issues of dissolution of marriage. And at the same point of time, the order which has been passed by the family court, be it an order of dissolution under Section 10 or divorce by mutual consent, which we see subsequently in Section 10A, all of these orders are final in nature. And the process, as is there, that the order will be appealable according to the Family Courts Act. This is also very different from how the law was framed and then continues to be mentioned in our bare acts, that once the decree nisi used to be passed by the district court, it was required to be approved by the High Court. So all of this has been done away with, and now the Family Court's order is the applicable order. Uh, Something very interesting about this law is it reflects the sacramental nature of marriage. So much so that when we say that there are Section 10, the marginal note says that these are grounds for dissolution of marriage. So the nature of marriage under Christian law is such that divorce is not accepted within the legal Christian religious system. And that also reflects in the framing of our statute by not using the word divorce. So it's not a decree for divorce, it's a decree for dissolution of marriage. The consequence, however, is the same, that the marital tie will come to an end. Something interesting that we should know about the evolution of this law, and how how it has come to be in its present form, and it can be used as a reflection on the other practices that exist in the other laws, is the discriminatory nature of Section 10 when it was originally passed. And it continued, that discriminatory nature of the law, gender discriminatory nature of the provision, continued till the year 2001. So, as we saw, Section 10 provides adultery as a ground for dissolution of marriage. However, this ground was made available differently for husbands and differently for wives. So, a husband only had to prove the ground of adultery, that is, the wife had committed adultery, and he could get a dissolution merely by proving adultery. On the other hand, a wife had to prove a material offense in addition to adultery. For instance, she had to prove that the husband has committed adultery and cruelty upon her, or that the husband has committed adultery and is in a bigamous relationship with someone else. So the burden of proof and I mean, more than the burden of proof, the requirement of the provision itself was different for husbands and it was graver for women. And this difference of treatment was continuously highlighted in various law reports, one of them being the report number 164. And the 15th Law Commission report also spoke about this. And in the Kerala High Court as well, it was challenged in the year 1995 in the case of Amini EJ versus Union of India, where the Kerala High Court said that the provision should be read without this additional burden. Uh, Having said that, it took the year 2001 to bring about this amendment and ensure that the provision is equal for both the husband and the wife. So, this is a positive step. And this can also help us reflect on various other decisions that are pending in the Supreme Court or Supreme Court, where provisions of other personal laws have been challenged for being gender discriminatory. I hope I was able to explain in brief the Christian personal law with respect to marriage and dissolution of marriage. I would now like to move on to the Parsi personal law. And here again, so we should remember that the Parsi personal law is in fact one of the oldest laws, personal laws, to have been codified by the British in India. And for the times that it was codified in, it was a very progressive law. It continues to be a progressive law because of the various grounds of divorce that have been given. Uh, but nonetheless, there are also limitations to this law which have been constitutionally challenged and which we will talk about shortly. So, the applicable law for both solemnization of marriage as well as the dissolution of marriage is the Parsi Marriage and Divorce Act of 1936. And the solemnizing event which gives legal validity to the Parsi marriage is the Ashirvad ceremony. It's a religious ceremony which involves the priests and invocation of certain religious verses from the text. And that is when, by the invocation of those verses and completion of those verses, the marriage is solemnized and creates the legal relationship of husband and wife. From marriage to the grounds of divorce, very similar grounds of divorce. However, some of these grounds here are such that are not found in the other laws. For instance, so the general grounds of divorce, which are common also, are that the marriage has not been consummated due to willful refusal of the defendant, or the defendant has been of unsound mind and has been habitually so of unsound mind. The defendant was made pregnant by some other person at the time of marriage. The defendant has committed adultery, fornication, bigamy, rape, or any other unnatural offense. The defendant has committed acts of cruelty. And here, the discretion of the court can be exercised. And instead of passing a decree of divorce, the court can also pass a decree of judicial separation. Conversion, that is, the defendant has ceased to be a Parsi. Now, an additional ground that we see here is that the defendant has caused grievous hurt to the plaintiff. This is different, and we don't see this ground in the other personal laws. However, this can be covered under the ground of cruelty itself. And in the other personal laws, of course, it will fall under the ground of physical cruelty. Now, the other grounds of divorce is that the defendant has inflicted the plaintiff with venereal disease, and the husband has forced his wife into prostitution, which has been recognized as a separate ground here in this law. And in the other laws, this is not a separate provision, but comes within the ground of cruelty. Then the defendant is undergoing a sentence of imprisonment for 7 years or more. The defendant has deserted the plaintiff for at least 2 years. And an order has been passed against the defendant to grant maintenance to the plaintiff, and the parties have not had marital intercourse for 1 year or more since the passing of such order. This is again an exclusive ground under the Parsi Marriage and Divorce Act, which we do not find under the other laws of divorce. Now, just like the other laws, this law also provides for divorce by mutual consent, where the living apart period between the couples has to be of 1 year or more. This is similar to the SMA, to the HMA, but not, as we observed, not under the Divorce Act. Then the couple has not been able to live together, and the couple has mutually agreed that the marriage should be dissolved. And similarly, to the general procedure of divorce by mutual consent, here also there are two motions to the petition, and then the final remedy is given with a cooling off period of 6 to 18 months, which is directory in nature and not mandatory. Similar, we have bars to the matrimonial remedy, that is, the act or omission which serves as the ground for divorce has not been condoned. Then the collusion, there is no collusion between the husband or wife. The plaintiff is not an accessory to any of the grounds, and there is no unnecessary or improper delay in the filing of the suit. Now, two critical legal issues which we should focus on and which are still pending with respect to the Parsi law of marriage and divorce are, first of all, that the Parsi law continues to follow in matters of divorce what is known as the jury system. So, if you see Chapter 3 of the Parsi Marriage and Divorce Act, it talks about Parsi matrimonial courts. And these matrimonial courts, when they are established in the presidency towns, they are known as the Parsi chief matrimonial courts. And when they are established in any other area of the country, they will be called the Parsi district matrimonial court. Now, these courts are established according to the orders of the High Court, and a judge of the High Court is the presiding judge of the Parsi matrimonial court. However, each of these courts, be it the chief matrimonial court or the district matrimonial court, each of these courts functions with the assistance of delegates. And these delegates are persons from the community itself. Usually, they are persons who are old and who have retired from their jobs, and they are nominated for a period of 10 years or more, and they have the choice to, they will have to not be part of the delegates by expressing to the nominator that they do not want to be part of it, or they are incapable of deciding the decision, the cases that have come before them. So the grounds to not be a part of the delegate system are also there. But the interesting thing is that this Parsi matrimonial court system continues to exist, and it is followed to this day. And as you will be able to observe, it creates a very different system for the Parsis to get a divorce as compared to a person of any other religion. And we see that this system has been challenged, constitutionally challenged, in a petition that has been filed with the Supreme Court in the year 2017. The petition is titled Naomi Sam Irani versus Union of India, wherein the petitioner she's the wife who's seeking the divorce, and she highlights that this jury system violates her rights under Article 14 and 21 because it delays, first of all, it creates a separate system of getting a divorce as compared to the rights that have been given to persons belonging to the other religious community. And at the same point of time, it delays her ability to get a divorce in a quicker manner. So, practically, what we see is that these delegates will not be sitting every day. It's not a continuously sitting court. And when some matters, they come, there are a few matters together that have been filed. That is when the jury will be nominated, they will sit for it, or they will, if they have already been nominated, they will be called, and they have to dispose of these matters quickly. They are also members of the community, and the community in itself is a very concentrated community. So it is possible that the plaintiff and the defendant may not want to discuss their personal affairs before the jury, before the delegates, whom they may even know, or since it's a small community, the chances of knowing them are way higher. So, as a result of this, it has been prayed to the Supreme Court that this jury system be abolished from the Parsi law of marriage and divorce. And also, very interestingly, this happens to be the only jury system in the country that we are still continuing. We've already under under the criminal law, we've already abolished the jury system, but here we are still continuing the jury system. So this happens to be a criticism, and hopefully, when this petition is decided, it will be decided in a positive and a progressive manner. Another area of the Parsi marriage and divorce law that we need to be aware of, and which also is pending before the Supreme Court in a review petition, is the gender discrimination between Parsi men and women when they marry outside their faith. So, when a Parsi man marries outside his faith, then the man will continue to exercise his religious faith. He will continue to be a Zoroastrian. And the children born from that marriage will also be Zoroastrians. However, if a Parsi woman is marrying outside the faith, then she loses her religious status. And at the same point of time, children who are born from that marriage will also not be considered to be Parsis. Now, this matter was highlighted before the High Court of Gujarat in the year 2012 in the case of Gulrukh M. Gupta versus Barjor Pardiwala, wherein Gulrukh, as the names are suggesting, Gulrukh is the woman who files this case. She's married to a man, Mr. M. Gupta. And her fear is that, there are certain practices of the community which can only be performed if the person is a Zoroastrian. For example, going to the sanctum sanctorum of the Parsi temple, or performing the final rituals in the Parsi community. They can only be performed if the person is a Zoroastrian. So Gulrukh was afraid that, if when the time will come when she'll have to perform the final rituals of her parents, she will not be able to do this because of this gender discriminatory system that exists within the Parsi law. And surprisingly, the majority opinion of the Gujarat High Court upholds this system. And the judgment is firmly based on religious doctrines, and doctrines that we are not using in the present day and age, such as the doctrine of merger of personality. So it is not the majority decision is not based on constitutional morality. Rather, it is firmly placed in the religious system where religions many times require that the personalities of husband and wife merge, and then the only dominant personality, legal personality that remains, or the social personality that remains, is that of the husband. The wife's personality is subsumed within the personality of the husband. So, on the other hand, the dissenting opinion is based on the Constitution of India, which says that this practice is gender discriminatory, but definitely not the majority opinion. However, on compassionate grounds, the court also says that, when that time comes in Gulrukh's life, she should be allowed to perform the final rituals of her parents. But it is also it puts in a caution that the judgment is not to be treated as a precedent for other cases. So Now this judgment has been put in review, and hopefully we will have from the Supreme Court a progressive judgment which bases its decision on the principles of the Constitution. Uh, I hope I was able to reach out to you regarding the Parsi law of marriage and divorce. I would now like to quickly come to the Anand Marriage Act, that is the Sikh law of solemnization of marriages. And we have the Anand Marriage Act from the year 1909. When before that, the Sikh community petitioned for a separate law which recognized and gave validity to the Anand Karaj marriage ceremony, where verses from the Guru Granth Sahib that have been composed by us by one of the gurus are recited, and the separate rituals are followed, which are special to the Sikh community. And it is the citing of these verses and the performance of the rituals that gives validity to the marriage. Now, the this petition was in historically made to the British Imperial Legislative Council, and then the act was passed. But till the year 2012, this act was limited in nature, in the sense that it did not have registration mechanism. And I mean, so the effect was that in substance, the law recognized Anand Karaj as a form of solemnization of marriage. But despite this following of this solemnization, there was no mechanism to register these marriages. And as a result, the members of the Sikh community had to register their marriages under the Hindu Marriage Act, which also says that the within the definition of Hindu, it also includes a Sikh person. So that was the consequence. When this was brought to light, the Parliament passed the Anand Marriage Amendment Bill in the year 2012. And through that bill, uh, uh, Arunji, I think your question is that the marriage between a Sikh and Hindu has to be solemnized under the, I suppose you want to say the Special Marriage Act. Uh, and not the SPA. But that's not the case. Under the Hindu Marriage Act, the definition of Hindu includes a Sikh person, so the marriage can be solemnized under the Hindu Marriage Act itself. There is no need to go to the SMA. Of course, if parties want, because of the benefits of the SMA, they can solemnize and register under the SMA. Like I was saying, the amendment bill was introduced in the year 2012, and this amendment specifically focuses on the registration of Sikh marriages, their legal recognition, and the registration. So the central government has passed this amendment, and Section 6, which has been introduced through this amendment, requires states and union territories to frame respective rules for the registration of Anand Marriages Act. And as we understand, registration serves various purposes and benefits. It helps in controlling cases of underage marriages or bigamous marriages. It helps in acting as a proof wherever the validity of the marriage has to be established, or sorry, not the validity, the factum of the marriage has to be established. The registration will help as a proof for that. It is useful in cases of inheritance. It is useful in cases of various government schemes and policies. And it is also useful when applying for passports and foreign travel. So, registration is a rather essential component of the marriage laws in the country. And this particular amendment of 2012 stated that the purpose is to facilitate registration, maintain a marriage register, and provide the certified extracts. So, this marriage register is also going to act as the requirement of for the compulsory registration of marriages, which again our courts and as well as our parliament have been continuously emphasizing upon. So, the Act, the amendment was introduced in 2012, and very recently in September 2025, the Supreme Court has given directions to state governments, to the central government, in the case of Amar Singh Chadha versus Union of India, that all states and all union territories in the country have to pass the necessary rules which will help in registering Anand marriages. And they say that so in this particular case, a limited writ was prayed, was filed to mandate states to pass the necessary rules so that the parties can secure the access to certification and the civil consequences, which we just spoke about. And right. The necessity of registration is in the form of residence, maintenance, inheritance, insurance, etc. And registration also serves safeguards, especially the interests of women and children who have to many a times procedurally provide the documentary proof. And this documentary proof also makes the proceedings easier for them, relatively easier for them. So the directions that were given by the court in this September 2025 case are that every state which is not already notified must do so within 4 months. So, some states like Kashmir had notified, Union Territory of Kashmir had notified the rules in the year 2021, 2023, and some other states had also done so. But many of the states were still lacking, which led to a different kind of registration mechanism for Sikhs within the states that had passed the rules and in states that had not passed the rules. And it is this aspect of difference of treatment that is focused upon by the court with its observation that in a secular country like ours, we need to have a registration mechanism which caters to, which provides for what is there in the law and implements the law in the manner that it has been envisioned. However, the directions also state that till the rules are not notified, the state should register the Anand marriages under the general law of registration. But at the same point of time, they should mention on the certificate that the marriage has been solemnized as per the Anand marriage rules. This was something that was not being done, or there was a lot of hesitation in doing so earlier. And that is why this particular directive by the Supreme Court. There are also additional directives in the manner of certain special directions given to the state of Goa, to the state of Sikkim, and also nodal officers to be appointed for the purposes of ensuring that the rules are framed and then that register is maintained. So those guidelines are also there, but these directions can only come into effect after the rules have been properly framed by each state government and the union territory. Now, what is lacking in the Anand Marriage Act is it is still a law that only recognizes and registers the marriage solemnized through the Anand Marriage Act. However, it does not provide for divorce, it does not provide for maintenance, and the grounds for divorce, maintenance, custody, etc. Those grounds are the same as are mentioned under the Hindu Marriage Act. So, Section 13 for fault based grounds and then 13B for mutual divorce is what will be applicable in the case of Sikhs, even if they register their marriage under the Anand Marriage Act after the rules have been framed. And this has also been highlighted to be a limitation of this particular law. Now, lastly, I would like to come to the topic of maintenance under each of these laws. And as we understand that there are two forms of maintenance that are given, interim maintenance and permanent alimony and maintenance, or the final maintenance order. And both of these serve different purposes. So interim maintenance is given during the proceedings. These proceedings could be for divorce, for restitution, for annulment, and or for judicial separation. And the permanent alimony or maintenance will be granted at the time when these proceedings have come to an end, or at any time subsequent thereto when an application is made to the relevant court. Now, under Parsi law, interim maintenance can be made by either the wife or the husband. And in all cases of maintenance, as has been now crystallized in the case of Rajneesh versus Neha, assets and liabilities of both spouses will be taken into account. Now, these assets and liabilities, the whole affidavit should be factors which are given in the affidavit must be looked into, and the amount of interim maintenance or the amount of permanent alimony and maintenance should be accordingly decided. Interim maintenance also serves another purpose, that is the purpose of bearing the costs of the proceedings, which the petitioner may not have at that point of time. So, Parsi law, the petition can be made by either the wife or the husband. It is when the petitioner is unable to support themselves or unable to bear the expenses of the proceedings. And the period when through which this amount will be disbursed will be either weekly or in the form of monthly sums. Similarly, under Christian law, we see that it covers the expenses of the proceedings, and again, regard has to be had to the assets and liabilities of both spouses. However, under Christian law, interim maintenance and also permanent maintenance have to be given only by the husband. So here it is not a gender neutral provision as we see in the case of Parsi law, or even under the case of Hindu law, where Sikhs can get the maintenance under. So under HMA, the provision for maintenance pendentolite tells us that it can be awarded to the husband or to the wife. And the applicant does, when the applicant doesn't have an independent income to bear the necessary expenses or the costs of the litigation, this disbursement is done in the form of monthly sums, or if any other mechanism is required, then the discretion of the court can be exercised. And again, the assets and liabilities of both spouses will be taken into account. Permanent alimony and maintenance, like I stated earlier, will be given once the proceedings have come to an end. Under Parsi law, it is that the permanent alimony and maintenance can be granted either to the wife or the husband. It is a mechanism of financial support which is provided, and permanent alimony and maintenance is always for the duration of the life of the recipient. It is also based on the conduct of the parties. That is, if the petitioner has displayed any conduct which might deprive the petitioner of that maintenance, court can exercise its jurisdiction accordingly. And usually the nature of these payments is in gross sum or monthly periodical payments, which is why the use of both the words alimony as well as maintenance. And here, as per the guidelines of Rajneesh versus Neha, under any whichever law the parties are seeking to get the maintenance, they should submit the affidavit of assets and liabilities, which should be and that should also be asked by the court, so that there is a just payment of this financial support, and it doesn't become a sort of penalty for the one who is paying the maintenance, and at the same point of time it is sufficient for the recipient to be able to live a life of dignity. So Parsi law, we see that either the husband and wife can get it, but Christian law, it is only the wife who is eligible to get maintenance. And under Hindu law, again, either the wife or the husband can be awarded permanent alimony. So I hope this was this made sense. Thank you so much again for this opportunity, and I'm open for any questions that the participants may have.
Yes, sir. Thank you very much, sir. Yes, participant, any question query, please raise your hand. Advocate Vasanta. I'm sure, like most for the most of the participant, it may be new content. Because we are just focusing on Hindu and Muslim only. Yes, bro.
So good evening, madam.
Good evening, ma'am.
Thanks for the very insightful session, madam. Madam, I have a question and actually doubt. You have mentioned that if one of the spouse has to prove that the ground of divorce is adultery, that it should be coupled with the bigamous marriage. What
Yes.
if the spouse continue to be in adultery without being marrying second time?
Ma'am, actually, this used to be the provision earlier, and now it has been removed from the law book. Earlier, the law used to say till the year 2001, Section 10 was divided in two parts. Section 10 of Divorce Act, which is only applicable on the Christians, it was divided in two parts, wherein the husband was only required to prove that the wife has committed adultery, but the wife had to prove that the husband has committed adultery and bigamy, for instance. Now, as you said, it is very difficult to be able to prove this to the court, and it is also an additional burden on the wife as compared to the husband on the same ground of divorce, that is adultery. So this doesn't have any relationship. In terms of Article 14, this is a very unequal provision. So it has been removed, and now under no law of divorce in all of our personal laws, under no law of divorce are we required to prove that the other party has committed an offense, a material offense, in addition to adultery. Earlier, as you say, if that would have been the case, that the wife is unable to prove bigamy and only adultery, before 2001, she may not have been able to get a decree of dissolution of marriage.
Any other question, participants? Yes, Arun, do you have question, Arun, or I think it's clapping, not questions. So,
Thank you. Thank you, sir. Thank you.
yes, any last question, participant, before we wind up? Sorry, it had been long day for all of you since 5:30. Okay, I think there are no more questions. So, yes, last question from Arun.
Yes, just one question. It's more of a. I am very thankful for such a nice and enriching session. And just one question that in the Hindu Marriage Act, grounds for divorce are equal for both men and women, husband and wife. But at the same time, it is very easy for women or the wife to get the divorce from the husband under the V Law of Domestic Violence Act of 498A. Rather, the husband do not have any provision in that manner. So do you have any comments on this?
Sir, thank you for your question. But I do firmly believe that these special laws or the special provision of 498A, these exist because of the systematic discriminations that have happened against women throughout and globally. It is not just in India. Globally, we have seen that within the institution of marriage, because of economic reasons, because of social reasons, and religious reasons, the husband has had a sort of dominant position in that relationship, which sometimes some men have abused, and as a result of that, committed acts of violence upon their wives. Having said that, I also firmly am against the idea that these laws are being misused. So this is where the judiciary, the execution mechanism in the through the police, they have to be really active. For example, when it comes to 498A applications, Many a times we've seen that the police is not applying its mind, and the police, as a routine manner, is imprisoning in the first instance everybody in that house. It could be somebody as old as 90 years, the grandparents, and somebody as young as 7 years old, the nephew, nieces, and young children in the house. So this has to be practically seen that I will not advocate for the removal of these provisions. I also am not of the school of thought that we need separate provisions for husbands. But what I do firmly believe in is that we need proper implementation of these laws. Lawyers also many a times they misadvise women. They say that, in order to get a quicker divorce, we'll file all of these applications so that the husband is coerced into giving you a divorce by mutual consent. The husband does not contest the divorce. So, this kind of industry practice also needs to be, we all need to introspect. And we need to ensure that when we are discussing the law, giving legal advice, and at the same time, those of us who are in the capacity of executing the law, we are doing it in a just manner.
Thank you very much, Shreya. I think thank you all participants. So, on behalf of organizing committee, we are grateful for you for your insightful session. Especially, this was very unique one because we keep focusing on Hindu and Muslim like most of the time. And I think there should be paper, family law, three papers should be there if you want to cover entire thing. So, once thank you very much once again, and look forward to see you in future programs also. Thank you.
Thank you so much, sir. Thank you. Thank you.
Thank you, participant, for joining. See you tomorrow. Thank you.
Thank you.